The room is packed to capacity. Not a single empty seat, and the crowd carries that low, eager buzz that comes when they expect something dramatic. I sit at the defense table next to my attorney, Tyler Benson. He's 28, appears even more youthful, and others never take him seriously. And that's precisely what works in his favor. Across the aisle, Emily and Ryan sit with their lawyer, Eric Lowell. My daughter looks polished, professional, like she's about to pitch a lifestyle brand to investors. Her husband has that self-satisfied smirk he wears when he thinks he's winning. Lowell shuffles papers, confident. Judge Cole Madison lounges behind the bench like he's at a country club. 61, tanned silver hair swept back. He's been needling me all morning with little jabs, throwaway comments about not wasting the court's time, and realistic expectations for settlement. The gallery eats it up. Some of them know Ryan from his investor circles. They think this is entertainment. I've been sitting here for an hour, watching Emily avoid my eyes, watching Ryan whisper to Lowell, watching the judge telegraph his contempt for an old man who dared fight back against his own daughter. The bailiff shifts in his chair. The court reporter's fingers hover over the keys. Someone in the back row coughs. Judge Madison leans back, that lazy smile still playing at the corners of his mouth. "Mr. Dawson, do you have anything to add before I rule on this matter? Or shall we save everyone some time?" The gallery titters. A few people actually laugh. Tyler's hand is steady on the table. He doesn't look at me, doesn't signal. We've been over this 100 times. Now it's my turn. I stand. Slowly. The kind of slow that makes people stop and look. My knees creak a little. 59 years and a bad back from a fall on a construction site 8 years ago. But I straighten to my full height, and the movement cuts through the room's ambient noise like a knife. The bailiff's pen freezes mid-note. The gallery hum drops to silence. Judge Madison raises an eyebrow, that amused look still on his face. Emily finally glances over, and for just a second I see something flicker in her eyes. Uncertainty, maybe, or recognition. Ryan leans forward, elbows on the table. Tyler slides a leather binder across to me. I rest my hand on it, but don't open it yet. I take a breath. The courtroom holds its breath with me. The judge's smile begins to fade. And then, before we continue, we ask you to hit the hype button, subscribe, and like the video to help the channel grow. Tell us which city you are from in the comments. We would like to get to know our audience better. 6 months earlier, Sunday morning. I'm on my second coffee, reading the engineering specs for a commercial retrofit downtown when the doorbell rings. I'm not expecting anyone. Rachel, my ex-wife, lives across town and doesn't drop by unannounced. Emily and Ryan are probably at brunch somewhere, posting about it. I open the door. A courier stands there with a manila envelope and a tablet. "Michael Dawson?" "That's me." "Sign here." I sign. He hands me the envelope and walks away like he's done this 1,000 times. Probably has. I close the door, set my coffee on the hall table, and open the envelope right there in the entryway. Legal complaint. 23 pages. The paper is expensive, cream-colored, heavy stock. Petitioners: Emily Dawson Hartley and Ryan Hartley. Respondent: Michael Dawson. I flip through it once, fast, trying to understand the shape of it before the details drag me under. Then I read it again, slower, feeling my pulse start to hammer in my temples. They want everything. The house, claiming some kind of constructive trust, arguing that because I helped with their down payment 2 years ago, I somehow owe them equity in my home now that they're building a family. They want distributions from my retirement accounts. They want a piece of my consultancy, claiming my client relationships constitute a marital asset that should be equitably distributed to support generational wealth building. I read that phrase 3 times. Generational wealth building. My daughter, my Emily. The kid I raised alone for 6 years after Rachel and I split. The kid I drove to soccer practice, helped with college applications, co-signed her first apartment lease, Walked down the aisle 3 years ago while she smiled at Ryan like he was the answer to everything. I set the complaint on the kitchen counter and pull out my phone. Open Instagram. Emily's recent posts are all gratitude and growth. So blessed to be building something meaningful. A curated nursery tour video, soft lighting, her hand on her barely visible bump. Creating space for the next generation. The comments are full of heart emojis and congratulations. There's an email too, forwarded in the discovery attachments. From Emily to Ryan, sent from her work address at the lifestyle company where she's brand director. Subject line: removing barriers. Dad's being difficult about releasing capital. He doesn't understand modern family structures or how wealth should flow to support the next generation. We need to move forward with legal options. He's a barrier to generational momentum, and honestly, I think he's holding on to control out of spite. Time to force the issue. I screenshot everything. Timestamps, device IDs, metadata, old habits from years of forensic documentation for construction litigation. Then I sit down at the kitchen table and stare at my coffee until it gets cold. My hands are steady. That surprises me. I thought they'd shake. The house is quiet. It's a good house. I bought it 12 years ago, after the divorce was final and I needed something that was just mine. 3 bedrooms, small yard, enough space for Emily to visit with her own room when she was in college. I've kept it maintained, updated the roof 4 years ago, replaced the HVAC 2 years back. It's solid, it's mine, and now my daughter wants to take it. I pull out a yellow legal pad, I still keep them around, habit from before everything went digital, and start making notes. Dates, amounts, conversations I remember. The down payment help. $20,000 given as a gift. I'd told her explicitly, "This is a gift, Em. You don't owe me anything." She'd hugged me, thanked me, told me I was the best dad in the world. That was 2 years ago. Different lifetime. My phone buzzes. Text from Emily. "Dad, I know you got the papers. This doesn't have to be ugly. We can work this out like adults. Call me." I don't call. Instead, I forward the text to my email, screenshot it with the timestamp visible, and save it to a folder I title Emily v. Dawson. "You declared a war on a guy who pours footings for a living. You'll meet the rebar. The first hearing is 2 weeks later. Judge Madison presiding. I've filed a response through a general practitioner I know from a building dispute 5 years ago. His name is Kent Wallace, competent, but not a fighter. He presents my position. The lawsuit is baseless, vindictive, an attempt to leverage family connection into financial gain. The down payment was a gift, documented as such for tax purposes. The retirement accounts are mine, untouchable under any reasonable interpretation of law. The consultancy is a sole proprietorship built over 30 years of my own sweat and reputation. It's all true. It's all reasonable. And none of it matters." Lowell, Emily's attorney, is smooth. He talks about fractured family dynamics and an aging parent's failure to adapt to changing economic realities. He makes it sound like I'm the problem, like I'm clutching assets while my daughter struggles. He uses words like intergenerational equity and family wealth management and estate planning failures. Emily sits there looking sympathetic, like this hurts her more than it hurts me. Ryan looks earnest, concerned, like he's just trying to support his wife through a difficult family situation. I want to laugh. I want to stand up and tell everyone in the courtroom exactly what Ryan Hartley is, a 35-year-old con artist who calls himself a performance investor and makes his money by attaching himself to people with actual resources. But I don't. I sit there and take notes while Kent argues and Lowell counters and Judge Madison looks bored. The judge barely glances at my filings. He grants their motion for temporary restraints. Restricted access to my house. I can live there but can't sell or refinance without court permission. Partial freeze on my consultancy's operating account pending full asset disclosure. Discovery schedule tilted their way. I have to produce documents within 2 weeks. They have 6 weeks to respond to any of my requests. Kent tries to object. "Your Honor, This is extraordinary relief at a preliminary stage. There's no evidence of asset dissipation or counsel. Madison's voice is flat. The petitioners have presented a prima facie case that the respondent's assets may be intermingled with family support obligations. The court finds temporary measures appropriate, pending full discovery. Next motion. Prima facie case. That's legal speak for I believe them and not you. As we're packing up, Judge Madison looks at me directly for the first time. Mr. Dawson, I'd encourage you to think seriously about settlement. These family matters can get very ugly very quickly. Sometimes the best thing is to recognize when it's time to compromise. Kent nods, trying to look professional. I just stare at the judge until he looks away. In the hallway outside the courtroom, Ryan corners me while Emily talks to Lowell near the elevators. Kent has already left, probably relieved to be done with the hearing. Ryan steps close, invading my space in that deliberate way people do when they want to intimidate without actually touching. He's 3 inches taller than me, gym fit, wearing a suit that costs more than my monthly mortgage. Michael. He doesn't call me Dad, never has. This can go easy or hard, your choice, but you need to understand, we have friends. The judge? He's reasonable, but he expects cooperation. And Emily deserves better than watching you cling to money you're just going to leave behind anyway. I don't step back. I keep my hands at my sides, my voice level. Is that a threat, Ryan? It's reality. He smiles, and it's the smile of someone who's never been told no in his life. We have friends on the bench, friends in the business community. You fight this and we'll bury you. We'll ruin your license, your reputation, everything. Or you can be smart, settle for something reasonable, and we all move on. Friends on the bench, I repeat. My smartwatch is recording, one-party consent state. Every word going straight to encrypted cloud storage with hash verification. That's right. He leans in closer. So think about it. Because the next hearing? It's going to be worse. Judge Madison doesn't like people who waste his time. Emily calls his name. He steps back, straightens his jacket, and walks away. I stand there in the hallway for a full minute after they leave, watching people flow past me. Attorneys, claimants, accused parties, and clerks. Everyone moving through the legal process the way a steady stream runs through a set of channels. Then I pull out my phone and check the recording. Clear audio, perfect timestamp, cloud sync confirmed. I play it back once, listening to Ryan's voice. We have friends on the bench. Beautiful. I take the stairs down instead of the elevator. My back complains, but I need the movement, need to think. By the time I reach the lobby, I've made 2 decisions. First, Kent Wallace is fired. Nice guy, but this isn't a nice guy situation. Second, I need someone who understands that law isn't about justice. It's about process. I find Tyler Benson through a construction attorney I've worked with on forensic cases. You want someone who'll fight dirty but stay legal, she tells me over the phone. Tyler's your guy. Young, brilliant with procedure, absolutely relentless. Tyler's office is in a converted warehouse downtown, shared space with 3 other solo practitioners. He meets me in a conference room that's all exposed brick and reclaimed wood. He's wearing jeans and a button-down, no tie, and he looks like he should be studying for the bar exam, not taking cases. Mr. Dawson. He shakes my hand. Firm grip. I read the complaint you sent over. It's creative. I'll give them that. Creative. I sit down. That's one word for it. Completely without merit is another phrase. He opens his laptop. But that doesn't matter if the judge is buying it. Tell me about the first hearing. I tell him. Everything. The temporary restraints, Madison's attitude, Lowell's performance, the hallway encounter with Ryan. I pull out my phone and play the recording. Tyler listens without interrupting. When it's done, he leans back and grins. It's not a nice grin. It's the grin of someone who just found the loose thread in a sweater. Okay, he says. Okay, this is good. Good? They made mistakes. Multiple mistakes. First, that recording is gold. Attempted witness tampering. At minimum. You're a court-certified construction expert. You've testified in this jurisdiction before. He's threatening your license and reputation to influence your cooperation in litigation. That's a problem for him. He types something. Second, their petition is overreaching to a degree that suggests either desperation or arrogance. Third, the judge's behavior suggests potential bias. He golfs with Ryan's crowd, I say. I saw photos on social media a few months back. Tyler's eyes light up. Screenshots? Of course. Send them to me. Everything you have. Every social media post, every email, every text message. I want documentation of every interaction you've had with your daughter and her husband for the last 2 years. That's a lot of material. I know, and I'm going to read every word. He closes his laptop. Here's what we're going to do. We're going to bury them in process. Not illegal process, not dirty tricks. Just pure, legitimate, documented chain of custody procedure. We're going to subpoena records from Emily's employer. She used her work email for personal legal planning. That's discoverable. We're going to FOIA request court administration records, routine correspondence logs. We're going to pull every public record we can find on Judge Madison, Ryan Hartley, and any entities they're connected to. That sounds expensive. It is, but you're a forensic building engineer. You know how to document a failure. This is the same thing. We're going to document every crack, every weak joint, every place where their structure doesn't meet code. And then we're going to tear it down. I study him for a long moment. You really think we can win? I think they gave us weapons and don't even know it. He opens his laptop again. But I need total commitment from you. No cowboy moves, no emotional outbursts, nothing that gives them ammunition. Everything we do has to be airtight, documented, defensible. Can you do that? I think about Emily's email. Barrier to generational momentum. Yes, I say. I can do that. Good. He starts typing. Then let's get to work. I reduce my workload at the consultancy. My partner, Greg, who handles the business development side, isn't happy about it. Michael, we've got 3 active cases and 2 more in the pipeline. I need you. I know, I'm sorry, this is temporary. Is it the lawsuit? He knows about it. Had to tell him when the account freeze hit. You want to talk about it? No. I don't mean to snap, but it comes out sharp. I mean, I appreciate it, but I need to handle this myself. He backs off. Greg's a good guy. We've been partners for 8 years, and he's never asked for more than I can give. I set up a home office in my spare bedroom. 2 monitors, scanner, printer, filing cabinet. I buy a laptop with encrypted hard drive and set up a separate cloud storage account with 2-factor authentication and automatic backup. Every document gets scanned, renamed with a systematic file structure, and uploaded with verification hash. It takes me 3 days to organize everything I have. Then I start gathering what I don't have. Tyler sends me a list. It's 4 pages long. Every email Emily sent from her work address in the last 2 years, every social media post from both of them, every financial transaction you can document, gifts, loans, payments, property records for their house, business filings for Ryan's investment entities, Judge Madison's financial disclosures, their public record, charitable foundation records, contractor permits and business licenses for anyone who's done work for the judge. I work through the list methodically. Some of it's easy. Social media posts are public. I just screenshot and organize. Some of it requires formal requests. Tyler handles the subpoena to Emily's employer, but I draft the document request list. 27 items, each one specific and defensible. All emails sent or received by Emily Dawson Hartley from her company email address containing the terms Michael Dawson, legal action, attorney, settlement, assets, inheritance, trust, or financial planning. Their corporate counsel tries to quash it. Tyler argues in front of a different judge, not Madison, thank God, and wins. The company's policy is clear. Work email is company property, subject to disclosure in litigation. Emily signed the acknowledgement when she was hired. The emails arrive as a PDF dump, 347 pages. I read every one. Most of it's routine work stuff, but scattered through are conversations with Ryan, with friends, with her mother. She's been planning this for over a year. Long before she served me with papers, she was building her case. One email to a friend. Dad doesn't get it. He thinks family means something more than economics. That's so boomer. Wealth is a tool, and he's sitting on tools we could be using. Another to Ryan. The attorney says we can claim constructive trust if we can show he intended the gift as part of ongoing family support structure. I think I can testify to that. He's always talking about family legacy. I flag them all. Highlight, tag, cross-reference. By the time I'm done, I have a timeline that shows premeditation, coordination, and a deliberate misrepresentation of our relationship. Tyler reads it and whistles. This is better than I hoped. She's not just opportunistic, she's calculating, and she documented it. People always do, I say. They think email is private. It's not. No, it's not. The FOIA requests take longer. Court administration records are public, but they're slow to produce. I file requests for all correspondence logs between Judge Madison's chambers and any attorney appearing before him in the last year. I request visitor logs, scheduling records, and judicial financial disclosures. While I wait, I do something else. Something Tyler didn't ask for, but I know will matter. I start mapping connections. Judge Madison's financial disclosures show he's on the board of a charitable foundation called Community Legacy Partners. It's a small foundation, maybe $2 million in assets, focused on educational programs and youth development. Nice and vague. I pull their 9090 forms from the IRS database. Public record. The foundation received a $100,000 donation last year from something called Hartley Strategic Ventures LLC, Ryan's company, or one of them. He has 3 LLCs registered with the state, each one paper thin, probably just vehicles for moving money around. I dig deeper. Property records show Judge Madison owns his home free and clear, but he pulled permits last year for a major renovation. Kitchen, bathrooms, deck addition. Contractor, Summit Ridge Construction. Summit Ridge's business filings show the principal is someone named Trevor Grant. I search Trevor Grant plus Hartley Strategic Ventures and find a press release from 2 years ago announcing a strategic partnership between Grant's construction company and Ryan's investment entity. It's not a smoking gun. It's barely even smoke. But it's a connection, documented and time-stamped. I make a chart, Judge Madison in the center. Lines connecting to Community Legacy Partners, Summit Ridge Construction, Trevor Grant. Lines from Ryan to Hartley Strategic Ventures, to Summit Ridge, to Community Legacy Partners. A web. Not proof of corruption. I'm not alleging crimes. Just relationships. Just timing. Tyler looks at it and nods slowly. This is good work, but we have to be careful how we use it. We're not accusing anyone of anything illegal. I know. We're just documenting potential conflicts of interest that might create an appearance of impropriety. Exactly. And we're doing it all through legitimate public records. Every piece. He grins again. That sharp, predatory grin. Then let's keep going. The second hearing is scheduled for 6 weeks out. In the meantime, there's a status conference, basically a phone call with the judge to discuss discovery progress. Tyler handles most of it. I listen on mute while he and Lowell spar over production deadlines. Emily's side is slow walking their document production, claiming they need more time to gather financial records. Judge Madison sounds irritated. Counsel, we've been at this for 2 months. The petitioners filed this action. Surely they have their documentation in order. Your Honor, my clients are cooperating fully, but Mr. Dawson's requests are overly broad and burdensome. Let me see the requests. Pause. Sound of papers shuffling. These look reasonable to me, Mr. Lowell. You have 2 weeks to produce responsive documents or file a specific objection with legal basis. Understood? Yes, Your Honor. Mr. Benson, how is your client's production coming? We've produced everything requested, Your Honor. Uploaded to the shared discovery portal last week. Another pause. I imagine Madison scrolling through his notes, realizing we're ahead of schedule. Very well. Anything else? Tyler pauses, and I know he's about to plant a seed. Your Honor, we may need to request a continuance on the final hearing date. We've identified some additional witnesses we'd like to depose, and the scheduling may be tight. What witnesses? Business associates of Mr. Hartley's, Your Honor. Their testimony may be relevant to the economic claims in the petition. I can almost hear Lowell tense up through the phone. Your Honor, that sounds like a fishing expedition. It's standard discovery, Your Honor. If the petitioners claim that Mr. Dawson's assets are somehow entangled with family support obligations, we're entitled to explore the financial circumstances and business practices of the petitioners themselves. Madison sighs. Fine. File your notice of additional depositions within 1 week. Mr. Lowell, your clients will cooperate. Let's keep this moving, gentlemen. Next status conference in 3 weeks. The call ends. Tyler calls me right after. That went well. Did it? He's annoyed with their delays. That's good. And I got on the record that we're deposing Ryan's business associates. That's going to make them nervous. Will it? Michael, they're running a long con. The whole performance investor thing is smoke. I did some digging. Ryan's LLCs have minimal actual assets. They're pass-through entities. He's basically a middleman who takes cuts from connecting people with capital to projects. That's not illegal, but it's not the picture of success they're selling. If we start pulling on those threads in depositions, things are going to unravel. I lean back in my desk chair. Outside my window, a neighbor is mowing his lawn. Normal Sunday afternoon. So what's next? Next, we make them sweat. I'm going to notice depositions for 3 of Ryan's business contacts. We probably won't actually depose them. They'll fight it, and I'll withdraw the notices. But the threat alone is useful. While they're focused on that, we keep working on the real case. The judge, Tyler confirms. I got the correspondence logs from court administration this morning. There's nothing explosive in them, mostly just routine scheduling, but there's a gap. A gap? 3 days before the first hearing, there's no record of any filings or correspondence in your case. But Lowell's motion was granted with very specific language that suggests the judge had advance notice of the arguments. Either he's a faster reader than humanly possible, or someone briefed him off the record. My pulse ticks up. Can you prove that? Not yet, but I can build a circumstantial case, and circumstantial is enough to create an appearance of impropriety. Which is enough for recusal. He echoes. But we have to time it right. If we move too early, they'll cover their tracks. Too late, and we've waived the objection. So for now, we keep gathering evidence, and we keep our mouths shut. I hang up and go back to my charts. I add the correspondence gap as a note. Then I add another piece of information I found yesterday. The clerk who handles Judge Madison's calendar is named Dennis Polk. 32, been with the court for 6 years. Active on social media, posts a lot of check-ins at local restaurants and bars. I don't follow him. That would be obvious. But his profile is public. I scroll through his recent activity. Dinner at Granite and Rye 3 weeks ago. Drinks at the Waypoint last week. Posted a photo from a Nuggets game 2 months back. I cross-reference with Ryan's social media. Ryan was at Granite and Rye the same night as Dennis. Different tables, different groups, but same location, same night. Coincidence? Maybe. I flag it and keep looking. 2 days later, I'm walking past the Waypoint on my way back from a property assessment downtown. It's 8 p.m., dark, cold. The bar is busy. I glance in the window and see Ryan sitting in a booth with someone I don't recognize. I keep walking, circle the block, come back. They're still there. I cross the street, Stand in a coffee shop doorway where I have a clear sight line. My phone is in my hand, camera ready. 10 minutes later, Ryan and his companion leave. They stand on the sidewalk talking. I get photos. Clear faces, clear timestamp. Ryan's companion is Dennis Polk. I don't follow them. I don't need to. I have what I need. Proof of contact between Ryan Hartley and Judge Madison's clerk in a social setting, while active litigation is pending. Again, not a smoking gun. Not illegal by itself. But it's another thread. Another connection. I send the photos to Tyler with a note. Found these by accident. Thought you'd want to see. He calls me immediately. Michael, tell me you didn't do anything illegal to get these. I was walking by, saw them through the window. Public place, no expectation of privacy. Okay, good. He's breathing fast, excited. This is good. Combined with the correspondence gap and the foundation connections, we're building a pattern, not proof of corruption, but proof of access, proof of relationship. What do we do with it? Nothing yet. We let it ripen. But Michael. Yeah? This is dangerous territory. If they figure out what we're doing, they'll come at you hard. Are you ready for that? I think about Emily's email again. Barrier to generational momentum. I'm ready. Their document production finally arrives. It's a mess. Hundreds of files poorly organized, clearly designed to bury anything useful under sheer volume. But I'm used to this. Half my career is digging through contractor records looking for the one invoice that proves a timeline. I set up a system. Every document gets logged, categorized, and cross-referenced. I work through them methodically, 10 hours a day, pulling out anything relevant. And then I find it. It's in a subfolder labeled Personal Estate Planning. A post-nuptial agreement addendum signed 2 years ago, 6 months before Emily's wedding. It's notarized, legal, binding, and it explicitly excludes all parental gifts, loans, and support provided prior to or during the marriage from any claims of marital or family asset status. I read it 3 times to make sure I'm not hallucinating. Emily signed this. She agreed, in writing, that any financial support from me was separate from her marriage, not subject to claims by her or her spouse, and not considered part of any shared family wealth structure. It's a tactical nuke. It invalidates the entire legal theory of their petition. I call Tyler immediately. I found something. 20 minutes later, he's at my house, reading the document on my laptop screen. His hands are shaking slightly. Holy hell. Does this do what I think it does? It does exactly what you think it does. Their petition claims your gifts were part of an ongoing family support structure that created a constructive trust. But she explicitly waived any such claim in writing. This is game over for their economic argument. Why didn't they produce this earlier? Because they hoped we wouldn't find it, or they forgot about it, or, and this is my guess, it was buried so deep in their files that even Lowell doesn't know about it. He leans back, grinning. This is beautiful. This is absolutely beautiful. So we file a motion to dismiss? Not yet. If we file now, they'll scramble for a new theory. We save this for the final hearing. Drop it like a bomb when they least expect it. I nod slowly. What else do we need? We need to keep building the judicial bias case. The post-nup wins us the legal argument, but it doesn't win us sanctions. It doesn't hurt them. For that, we need to show that the whole process was rigged from the start. He's right. Winning isn't enough. I need them to lose everything. Over the next 2 weeks, I become nocturnal. I work during the day on consultancy projects. Enough to keep Greg happy, enough to maintain cash flow. At night, I hunt. I map every connection I can find between Ryan, Judge Madison, and the extended network of their social and business circles. I pull property records, business filings, donation records, permits, licenses. I cross-reference social media posts with credit card receipts, Ryan posts a lot of photos, often tagged with locations. When he posts from an expensive restaurant, I file public records requests for any business meetings or events held there by anyone in the judge's circle. It's tedious, grinding work. Most of it leads nowhere. But occasionally, I find something. A zoning variance approved for a property owned by an LLC that lists Ryan as registered agent. Approved by a city board that includes one of Judge Madison's former law partners. A speaking engagement at a legal conference where both Judge Madison and Eric Lowell were panelists. Not unusual by itself, but the conference was sponsored by Community Legacy Partners, the foundation that received Ryan's donation. Individually, none of it proves anything. Together, it shows a pattern of access and influence. Tyler reviews everything and nods. This is enough. We're not alleging conspiracy. We're just showing that the judge is part of Ryan's social and professional network, which creates at minimum an appearance of impropriety. When do we file the recusal motion? We don't. Not as a motion. We raise it at the hearing on the record as an objection to any adverse ruling. That way they can't prepare a defense. That's a gamble. It's a calculated risk. If we file ahead of time, they have weeks to spin it. If we raise it in the moment with evidence in hand, they have to respond cold. And if the judge rules against us anyway, we have immediate grounds for appeal, plus a judicial conduct complaint. I study him. You've done this before. Not exactly this, but I've gone after judges who thought they were untouchable. It's scary and it's risky and it can backfire. But when it works, he grins. When it works, it's the most satisfying thing in the world. The next status conference is tense. Lowell is aggressive, pushing for earlier hearing dates, trying to maintain momentum. Tyler is calm, measured, agreeing to nothing without extracting concessions. Judge Madison sounds impatient. Gentlemen, we've been at this for 4 months. I'm setting a final hearing for 6 weeks from today. Both sides will be ready. No more delays. Your Honor, Tyler says carefully, we may need to raise some preliminary matters at that hearing. What preliminary matters? Matters related to potential conflicts of interest that have come to our attention during discovery. Silence on the line. Then Madison's voice, sharp. You're not seriously suggesting... I'm not suggesting anything, Your Honor. I'm simply preserving our right to raise appropriate objections based on evidence we've gathered. If you have a recusal motion, file it. We're still evaluating our options, Your Honor. Another silence. Fine. You have 1 week to file any recusal motion. After that, the deadline is passed. Tyler doesn't hesitate. Understood, Your Honor. Thank you. After the call ends, Tyler texts me. That was him taking the bait. He thinks we're bluffing. I text back. Are we? No, but now he's nervous. Nervous judges make mistakes. 3 weeks before the final hearing, I'm in the parking garage near the courthouse, loading files into my car after a deposition in an unrelated case. It's late afternoon, overcast, the garage mostly empty. I hear footsteps echoing on concrete. Ryan appears from behind a pillar. Michael, funny running into you here. It's not funny, and it's not random. But I stay calm. My smartwatch is recording. I turned on the voice memo feature the second I heard footsteps. Ryan? I close my car door, keep the vehicle between us. What do you want? Just wanted to check in, see how you're doing. He walks closer, hands in his pockets, casual. This has been hard on Emily. On both of us. All this conflict, all this fighting. It doesn't have to be this way. Then drop the lawsuit. You know we can't do that, but we can settle. Reasonable terms, everyone walks away whole. He stops a few feet away. The alternative is we keep fighting. And Michael, you need to understand, we're going to win. The judge, he's a reasonable guy, but he expects cooperation. He's told me as much. I keep my face neutral. The judge has talked to you about our case? We're friends. We talk, and he's made it clear that he thinks your position is, let's say, unreasonable. Ryan steps closer. So here's what I'm telling you. Settle, or we destroy you. We'll ruin your license. We'll trash your reputation. We have friends everywhere, on the bench, in the business community, in the contractor networks you rely on. You'll never work again. Is that a threat? It's a promise. Last chance, Michael. Take the settlement or watch everything you've built turn to ash. I stand very still. You done? He smiles. Yeah, I'm done. He turns and walks away, footsteps echoing. I get in my car, close the door, and sit there for a full minute. Then I pull out my phone and check the recording. Perfect audio, every word. We're going to win. The judge, he's a reasonable guy, but he expects cooperation. He's told me as much. We're friends. We talk, and he's made it clear. We have friends everywhere. On the bench. I uploaded immediately. Cloud storage, hash verification, timestamp secured. Then I send it to Tyler with a message. Got something you need to hear. He calls 5 minutes later. Where are you? Parking garage near the courthouse. Stay there. I'm 10 minutes away. Tyler arrives, parks next to me, gets in my passenger seat. I play him the recording without preamble. He listens twice. The second time, he closes his eyes, and when it's over, he just says, "Oh, wow. Good? Good?" Michael, this is incredible. He just admitted to ex parte communication with the judge about a pending case. He threatened to use judicial connections to ruin your career. This is witness intimidation, attempted interference with an expert witness, and evidence of judicial bias, all in one tidy package. Can we use it? Absolutely. One-party consent state, recorded in a place where he had no reasonable expectation of privacy. It's admissible, and combined with everything else we have, it's devastating. I feel something loosen in my chest. Relief, maybe. Or vindication. So, what's next? Next, we finish building the case. We have 3 weeks. I want every piece of documentation perfect, every exhibit labeled and cross-referenced, every citation checked. When we walk into that courtroom, we're going to hit them with everything at once, and they won't see it coming. The next 2 weeks are a blur. I barely sleep. My consultancy work suffers, but Greg covers for me. I stop answering calls from everyone except Tyler. Rachel reaches out via text. Emily called me. She says you're being vindictive. I don't know what to believe. I text back. Believe what you want. I'm defending myself. She doesn't respond. Emily tries calling twice. I don't answer. She leaves voicemails. First message. Dad, please, this has gone too far. Let's just talk, family to family. I miss you. The baby's due in 3 months, and I want you to be part of their life. Second message, 2 days later. Fine. If this is how you want it, we'll see you in court. But you're making a huge mistake. You're going to lose everything, and it's your own fault. I save both messages. Evidence of manipulation followed by threat. Classic pattern. Tyler and I meet every other day, reviewing documents, rehearsing sequences, anticipating objections. He's meticulous, checking every detail twice. We get one shot at this. If we screw it up, they'll bury us. We won't screw it up. No, he agrees. We won't. 5 days before the hearing, I do one final check of my evidence archive. Everything is organized. The post-nup addendum, the parking garage recording, the social media connections, the foundation donations, the clerk meetings, the correspondence gaps, the contractor permits. Each piece individually defensible, collectively damning. I make a binder for myself, 300 pages tabbed and indexed. I know where every document is without looking. Tyler has his own set. The key is pacing. We don't lead with the post-nup. That ends their case, but doesn't hurt them personally. We start with the evidence that shows premeditation and manipulation, build to the judicial bias evidence, then drop the post-nup as the knockout. The parking garage recording comes last, right before we file the judicial conduct complaint. You really think he'll recuse? He'll have to. Once that recording is public record, his career is on the line. He recuses, vacates all his prior orders, and we start over with a new judge, at which point Lowell will advise them to settle immediately or face sanctions. And if he doesn't recuse? Tyler's smile is cold. Then we file the judicial conduct complaint in open court, release everything to the press, and watch his world burn. Either way, we win. The night before the hearing, I can't sleep. I lie in bed staring at the ceiling, thinking about Emily as a kid, her elementary school talent show where she sang off-key but with complete confidence, her high school graduation, her wedding day when she hugged me and whispered, "Thank you for everything, Dad. I love you." Did she mean it then? Or was I always just a resource to her, something to be managed and eventually liquidated? I don't know. And somewhere along the way, I've stopped caring. At 3 a.m. I get up, make coffee, and review my notes one last time. Everything is ready. Every document, every exhibit, every word I'm going to say. Tyler texted me at midnight. "Get some sleep. Tomorrow, we end this." I text back now. Ready. The courtroom is crowded, every seat taken, and the audience gives off that low, expectant hum people get when they sense something dramatic about to happen. I recognize some faces, contractors I've worked with, a couple of other building engineers, someone from the local business journal. Word got out that this hearing would be interesting. Emily and Ryan sit with Eric Lowell at the petitioner's table. Emily looks tired, drawn. Ryan looks confident, almost smug. Lowell has 3 banker's boxes of files stacked next to him, trying to project overwhelming preparation. Tyler and I have 2 small leather binders. That's all we need. Judge Madison enters and everyone rises. He settles behind the bench, arranges his papers, and surveys the room with that lazy satisfaction of someone who thinks he knows how this will end. Please be seated. We're here for final arguments in Dawson Hartley versus Dawson. Mr. Lowell, you may proceed. Lowell stands, and for 20 minutes he delivers a performance. He talks about fractured family relationships, generational obligations, economic fairness. He projects Emily's emails about building legacy and creating family wealth. He shows photos of the nursery, of Emily and Ryan looking young and hopeful. He makes it sound noble, makes it sound like they're the ones being wronged. Your Honor, the evidence is clear. Michael Dawson has assets that he accumulated with the support and involvement of his family. His daughter worked for his consultancy during college summers. He promised to help secure their financial future. And now, when they need that help most, he's refusing out of spite and control. The law recognizes constructive trusts precisely for situations like this, where promises and expectations create equitable obligations that transcend formal documentation. He sits down. The gallery murmurs. A few people nod. Judge Madison looks pleased. Mr. Benson? Tyler stands. He doesn't go to the podium. He stays at our table, hand resting on his binder. Your Honor, before we address the merits, I need to raise a preliminary matter. We've discovered evidence during discovery that suggests potential conflicts of interest that may warrant recusal. Madison's expression hardens. We've been through this, counsel. You had a deadline to file a recusal motion. We preserved the issue, Your Honor, and the evidence we've gathered goes directly to the integrity of these proceedings. Lowell stands. Your Honor, this is a transparent delay tactic. It's not a delay, Your Honor. Tyler opens his binder. It's a necessity, and I'd ask the court's indulgence to present our supplemental disclosures. Madison looks like he wants to refuse, but there are reporters in the gallery, and he knows that shutting down a judicial bias claim without hearing it would look terrible. Fine, make it quick. Tyler nods to me. I stand, pull out my binder, and hand Tyler the first exhibit. He walks it to the clerk, provides a copy to Lowell, and projects it on the courtroom screen. Your Honor, this is a post-nuptial agreement addendum executed by Emily Dawson Hartley 2 years ago. It explicitly excludes all parental gifts and support from any claim of marital or family asset status. The courtroom goes quiet. Emily's face drains of color. Ryan leans over to Lowell, whispering urgently. Lowell stands. Your Honor, we weren't aware of this document. It was in your document production counsel. Folder labeled Personal Estate Planning. Tyler's voice is level. It's dated, notarized, and legally binding. It invalidates the entire legal theory of the petition. Madison stares at the document. Mr. Lowell? Your Honor, I need time to review this and consult with my clients. You've had 4 months to review your client's documents. Tyler doesn't let up. But that's not even the most significant issue we need to address. He hands me another exhibit. I pass it forward. Recording transcript, verified and certified. This is a transcript of a conversation between Ryan Hartley and Michael Dawson, recorded 3 weeks ago in a public parking garage. In this conversation, Mr. Hartley explicitly threatens to use his connections on the bench to destroy Mr. Dawson's reputation and career. He states, and I quote, "The judge is a reasonable guy, but he expects cooperation. He's told me as much." He further states, "We're friends. We talk." The courtroom erupts in whispers. Madison goes pale. Your Honor, Tyler continues, we have authenticated audio of this conversation. We also have photographic evidence of multiple social meetings between Mr. Hartley and Dennis Polk, your judicial clerk, at times when this case was active and pending. He projects the photos. Ryan and Dennis at the bar. Timestamps, locations, clear faces. We have donation records showing that an LLC controlled by Mr. Hartley made a 6-figure contribution to a charitable foundation on which Your Honor serves as a board member. We have permit records and invoices showing that a contractor associated with Mr. Hartley's business interests performed renovation work on Your Honor's residence. Lowell is on his feet. Your Honor, this is a smear campaign. It's documented fact, Your Honor. Tyler's voice cuts through the noise. Every document I'm presenting is authenticated, verified, and obtained through legitimate discovery channels or public records requests, and taken together, they establish at minimum a clear appearance of impropriety that requires recusal under judicial conduct standards. Judge Madison's hands are shaking. These are serious allegations, Mr. Benson. They're not allegations, Your Honor. They're facts. And I'm not accusing you of any crime. I'm simply noting that the evidence shows connections and communications between the petitioners and this court that create an appearance of bias which renders any ruling in this case subject to immediate appeal and judicial conduct review. The room is silent now. Everyone watching, everyone waiting. Tyler reaches for the final exhibit. Your Honor, before you make any ruling, I want you to know that we've prepared a comprehensive complaint to the Judicial Conduct Board documenting all of this evidence. We've also prepared a press packet. Both are ready to file the moment this hearing concludes. He lets that hang in the air. However, he continues, if Your Honor were to recuse yourself now, vacate all prior orders as potentially tainted by the appearance of bias, and allow this case to be reassigned to a new judge, we would be willing to hold our conduct complaint in abeyance pending the outcome with an unbiased tribunal. It's a threat and an offer simultaneously. Recuse or be destroyed. Madison looks at Lowell. Lowell looks at his clients. Ryan's face is red, furious. Emily is crying silently. Your Honor, Lowell says weakly, my clients had no knowledge. Your clients, counsel, are on recording threatening a court-certified expert witness. Tyler doesn't even look at him. That alone is grounds for sanctions, but we'll address that with the new judge. I stand up. Tyler glances at me, surprised. We didn't plan this. But I know what I need to say. Your Honor. Madison looks at me like I'm a ghost. Before you rule, I want you to take judicial notice of one more document. I pull it from my binder. Exhibit R, a FOIA-produced email from your chamber's automated system, acknowledging receipt of a file titled Dawson Talking Points, sent from an email address registered to Ryan Hartley 3 days before our first hearing. I hand it to Tyler. He walks it forward, hands shaking slightly. It's a simple document, an auto-reply acknowledgement. Thank you for your email. Your message has been received and will be reviewed by Chambers staff. Sender, ryan.hartley@ventures.com. Recipient, chambers.madisoncourt.gov. Subject, Dawson talking points. Date, 3 days before the first hearing. Not a single sound can be heard in the room. Tyler speaks quietly. Your Honor, this is an ex parte communication about a pending case. Combined with everything else, it demonstrates not just an appearance of impropriety, but actual impropriety. He pulls out his phone. I'm filing the Judicial Conduct Board complaint now. I'm sending the press packet now. He taps the screen. Send. Your Honor, he says, you're welcome to rule however you like. But I want you to understand that as of this moment, every decision you make in this courtroom is national news. The legal blogs will have this in an hour. The State Bar will open an investigation by end of day. And every ruling you've made in the last year will be scrutinized for similar conflicts. Madison stares at him, then at me, then at the transcript on his bench. His career is over, and he knows it. This court, he says slowly, will take a 15-minute recess. The bailiff calls recess. Madison flees to his chambers. The gallery explodes in noise. Reporters are typing furiously. Lowell is bent over his phone. Emily is sobbing. Ryan is frozen, staring at nothing. Tyler grabs my arm. We did it. I don't feel victorious yet. I feel cold, focused, waiting for the final blow. 15 minutes later, the bailiff calls us back. Judge Madison looks like he's aged 10 years. This court hereby recuses itself from this matter due to the appearance of impropriety raised by the evidence presented. All prior orders are vacated. The case will be reassigned to a new judicial officer for fresh consideration. He looks at Lowell. Mr. Lowell, you should advise your clients that the new judge will likely consider motions for sanctions based on the evidence of improper communications and witness intimidation. This court strongly encourages settlement negotiations. He bangs the gavel once. We're adjourned. And just like that, it's over. The hallway outside the courtroom is chaos. Reporters try to corner Tyler. He gives them a brief statement. Justice requires integrity. We're pleased that the appearance of impropriety has been addressed. We look forward to presenting our case to an impartial tribunal. I don't talk to reporters. I stand near the elevator, watching. Emily and Ryan come out. She won't look at me. He's on his phone, yelling at someone. Lowell looks sick. Tyler pulls me aside. Michael, we need to talk about next steps. What next steps? We won. We won this round. But there's still the new hearing, the sanctions motion. They'll agree to a deal. My voice is steady, confident. Lowell knows their argument won't hold. The post-nup ruins their claim, and the recording exposes the pressure put on the witness. They'll settle in a week, tops. Tyler studies me. And if they don't? Then we go to trial and I testify about everything. Every manipulation, every threat, every lie. And we win anyway. He nods slowly. Okay, but Michael, this is going to follow them. The judicial conduct investigation, the press coverage. Their reputations are destroyed. Good. Your daughter declared war on me. My voice is flat. Used my love for her as a weapon. Tried to take everything I built. And she did it deliberately, calculatingly, with full knowledge of what she was doing. I look at him. She made her choice. Tyler is quiet for a moment. Then, okay, I'll draft the settlement demand. Full dismissal with prejudice, their attorney fees paid by them, and a public stipulation acknowledging that all claims were without merit. And the judicial conduct complaint? Stays active. That's not about them anymore. That's about him. He glances back toward the courtroom. Madison's done. He'll probably resign before the investigation concludes. Good. We take the elevator down. Outside the courthouse, the November air is cold and clean. I breathe deep, feeling tension drain from my shoulders for the first time in 6 months. My phone buzzes. Text from Rachel. I heard what happened. Call me. I don't call. Not yet. Another text, from a number I don't recognize. Mr. Dawson, this is Kent Wallace, your original attorney. I heard about the hearing. Congratulations. You did the right thing getting different counsel. Tyler Benson is excellent. I smile at that. Kent's a good guy. He just wasn't built for war. Tyler's phone is ringing constantly. Press, other attorneys, probably some of his colleagues congratulating him. He ignores it all. You want to get lunch? He asks. Celebrate? No. I shake his hand. I want to go home. Check on my consultancy. Make sure Greg hasn't burned the place down. Get back to normal. This was never about revenge for you, was it? Tyler says. It was about defense. It was about both. I meet his eyes. They tried to destroy me. I stopped them, and then I made sure they couldn't try again. By destroying them. By using the law. I shrug. Everything I did was legal. Everything was documented. Everything was true. If that destroys them, that's on them, not me. He grins. You know, you'd make a terrifying attorney. I'd make a terrible attorney. Too patient. I turn toward the parking garage. But I make an excellent engineer. And engineers know that the best revenge isn't dramatic. It's structural. You don't blow up the building. You prove it was never up to code. I walk away, leaving him on the courthouse steps. My car is where I left it. I get in, start the engine, and sit for a moment in the concrete silence of the parking garage. Emily's message is still on my phone. You're going to lose everything, and it's your own fault. I delete it. Then I pull up my email and start drafting a message to Greg. Final hearing today. Issues resolved. I'll be back in the office full-time starting Monday. Let's talk about the industrial project. I have ideas. Normal. Back to normal. Except it's not normal and it never will be. My daughter is gone, not through any accident or tragedy, but through her own calculated choice to treat me as a resource rather than a person. My grandchild, Emily's baby, will be born in a few months, and I'll probably never meet them. That should hurt more than it does. But I'm 59 years old, and I've spent my whole career documenting structural failures. I know what collapse looks like. I know how to read the signs of rot, of shortcuts, of fundamental integrity failures that make a building unsafe. Emily and Ryan built their case on a rotten foundation. They thought intimidation and connections would substitute for actual merit. They thought I'd fold because fighting back was too hard, too expensive, too emotionally costly. They were wrong. I drive home. The house is exactly as I left it this morning. Kitchen clean, coffee maker ready for tomorrow, files organized in my home office. My house. Still mine. Still safe. I make dinner. Pasta. Simple. Fast. I eat standing at the counter, reading case law on my phone. Tyler sent me the proposed settlement demand. It's brutal, comprehensive, and leaves them no room to maneuver. They'll sign. They have to. My phone rings. Rachel. I answer this time. Michael. Hi. Are you okay? I'm fine. I don't understand what happened. Emily called me. She was hysterical. Something about judicial misconduct and press releases and... Rachel. I cut her off. They sued me. They tried to take everything. I defended myself. That's all. She's your daughter. She declared war on me. I keep my voice level. I didn't want this, but I'm not going to apologize for winning. Silence. Then, what happens now? Now they'll settle. Their case is finished. Their lawyer will tell them it's time to minimize the damage, and then we all move forward. She's having a baby, Michael. Your grandchild. I know. Don't you care? I think about that. I care, but not enough to let them destroy me. If she wants me in her life, in the baby's life, she knows how to apologize. Until then, I'm done being the villain in her story. Rachel is quiet for a long time. You've changed. No, I set my plate in the sink. I just stopped pretending that being a good father means being a doormat. That's harsh. It's honest. I look out my kitchen window at the backyard. Dark now, November cold. I spent 30 years building something. My career, my reputation, my home. She tried to take it all, and when I fought back, she called me vindictive. So yes, I'm done with that. Done being guilty for having boundaries. I hope you find peace with this. I already have. I hang up, and I realize it's true. I do feel at peace. Not happy exactly. There's no joy in losing your daughter even when she tried to ruin you. But there's satisfaction. Cold, structural satisfaction in having solved the problem correctly. In having documented every failure, every crack, every place where their case violated code. In having proved it on the record. My phone buzzes one more time. Text from Tyler. Lowell called. They want to talk settlement. Tomorrow 10 a.m. I'll handle it unless you want to be there. I text back. You handle it. I trust you. 3 dots appear. Then, we did good work. Yes, I type. We did. I turn off my phone. Pour a glass of water. Sit down in my living room with the lights off, looking out at the quiet street. Cole Street, my home. They tried to take it. They failed. And tomorrow I'll go back to work. Back to consultancy. Back to analyzing structural failures. Back to normal life. The life I built. The life I defended. I don't smile. I don't celebrate. I just sit in the dark, feeling the solid foundation of my house beneath me, and know that I won. Not because I destroyed them, though I did. Not because I exposed a corrupt judge, though I did that too. I won because I used the law exactly as it's meant to be used, as a weapon against people who think they're above it. Emily thought family connection would protect her. Ryan thought his network would carry him through. Judge Madison thought his position made him untouchable. They were all wrong, and now they know it.